बिस्मिल्लाहिर्रहमानिर्रहीम अस्सलातु वस्सलामु अलैका या रसूलुल्लाह वस्सलामु अलैका या हबीबल्लाह। प्यारे व्यूवर्स, उम्मीद करता हूँ आप तमाम दोस्त सब खैरियत से होंगे। अल्लाह ताला आप तमाम दोस्तों को सेहत के साथ लंबी ज़िंदगी अता फरमाए। और मेरी आप तमाम लोगों से दोस्तों से गुजारिश है कि मेरी हर इस वीडियो को शुरू से लेकर आखिर तक देखें ताकि कानून के बारे में आगाही हासिल कर सकें। और अपने नए आने वाले दोस्तों से गुजारिश करता हूँ कि मेरे इस चैनल को सब्सक्राइब कर लें, घंटे और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुँच सके। आज हम सेक्शन 164 की कमेंट्री पढ़ेंगे। कमेंट्री, स्कोप एंड एक्सटेंट। Statement under section 164 can be recorded either at the instant of complainant witnesses himself or at the instant of accused or IO. Magistrate cannot refuse to record statements under this section moved through lawyer PLJ 2002 LAH 533. Guideline for recording of confusional detail 2003 PCRLJ 1608. Confusional statement cannot be discarded due to some lapse on the part of magistrate 2004 YLR 1099. Recording of complainant statements on his request is a valid process which amount to be promote ends of justice and help in arriving at a correct decision by the court 2005 MLD 960. Statements under section 164 CRPC may be recorded not only at the instant of police but also at the instance of accused, aggrieved person, victim or that of witness himself 2005. YLR 1403. Statement of one accused against another cannot be read or reeled upon unless YLR 1403. Statement of one accused against another cannot be read or reeled upon unless and until it be inculpatory in nature and not exculpatory. PLJ 2005 SCAJK 65. Uncross examined statement is not a statement under the law. PLJ 2004 SC 294. नंबर 2, postponement of recording statement. Recording of statement of abductee cannot be deferred till arrest of accused NLR 2003 CR Lahore 523. Number 3, confusional statements. Two essential requirements: number 1, made voluntary, and number 2, must be proved at the trial. Absence of these requirements confusional, not a legal piece of evidence 2003 YLR 1481. Confusion by itself is not sufficient. Words uttered by accused should be reduced into writing and assess whether such words or language is compatible with alleged charge so as a constitute confusion 2003 PCRLJ 75. Court to determine it fairly 1983 SCMR 1292. Recorded behind the back of accused cannot be used against him. PLD 1978 SC Cat. An advertisement lapse, no reason to disbelieve. PLD 1978 SC Kiss. Witness making contradictory statement not reliable. PLD 1981 SC 472. कन्फ्यूजन ऑफ को अक्यूज नो एविडेंस 1982 SCMR 321, रिकॉर्डिंग ऑफ PLJ 1981 SC 52, 1982 SCMR 321 टू बी टेकन एज ए होल PLD 1983 SCAJK 199 obtained by Croatian justifiably refused PLD 1982 SCMR 321, exculpatory statement of co-accused to be used against the maker only PLD 1949 PC 326 dying declaration not affected by section 164 PLD 1951 FC 111 procedure to be adopted 1996 PCRLJ 528 confusion during illegal confinement 1996 PCRLJ 546 fear of accused must be removed 1996 PCRLJ 358, confusion of accused must be accepted in toto or not at all 1998 PCRLJ 1274, conviction of an accused can be founded on his voluntary confusion 1999 PCRLJ 381, confusion recorded after court hours 1991 MLD 392 form 1999 PCRLJ 903 910 delay explained 199 1991 PCRLJ 2007 delay of lapse not fatal if court is satisfied that such lapse not adversely affecting the voluntary and truth nature of confusion 2004 PCRLJ 1492 delay for recording confusion per se is no ground to discard same unless proved to have been obtained by Croatian threat pressure etc 2004 PCRLJ 1564 statement recorded under section 337 CRPC cannot be treated as confusion PLD 1991 PESH 124 accused handed over to police after recording confusion voluntariness of confusion affected 1990 PCRLJ 677 sufficient for conviction but as a role of prudence corroboration is shoot 1991 SCMR 942 confusion inculpatory 1992 PSC 568 FSC PLD 1991 SC 150 administration of oath and illegality 1992 PCRLJ 955 signed or thumb impression of accused required 1992 MLD 2455 confusion of one accused in the presence of an other accused may not be voluntary and may created a debt but the accused may not have freely exercised his will and that he may be under some threat or intimidation 1993 PCRLJ 227 confusion to be read as a whole confusion of one accused against co-accused is not sufficient for conviction even in Syria. 1997 PCRLJ 1639 neither record nor the statement of magistrate recorded in the court showing that accused was given sufficient time to lapse himself cannot be uh, held to be voluntary statements 2004 PCRLJ 1239 confusion not worthy of credit cannot be used against maker under section 342 CRPCPLD 1994 PESH attacked confusional statements alone cannot form sole basis for conviction PLD 1994 SC 314 confusion of co-accused not a substantive piece of evidence NLR 1995 SD 543 must be accepted or rejected as a whole 1994 PCRLJ 490 statement may become confusion 1994 PCRLJ 956 PLD 1964 SC 813 magistrate not fulfilling formalities 1995 MLD 519 important feature PLD 1993 LH 345 duty of court PLD 1993 LH 345 accused sent to police lockup after making confusion 1993 SCMR 1822 judicial confusion legal formalities 1995 PM confusion recorded after 3 days neither voluntary nor true 1985 PSC SC 609 confusion must be taken as a whole and is to be treated as a evidence but both for and against accused PLD 1999 KAR 151 recorded after long detention unsafe PLD 1999 KAR 151 unexplained delay fatal PLD 1999 SC 254 merely because confusion was recorded day or so before the police remand was to expire would not make the confusion involuntary AIR 1999 SC 2640 used for limited purpose not a substantive piece of evidence PLD 2005 FSC 161 deep used for limited purpose not a substantive piece of evidence PLD 2005 FSC 161 deep question required while relying on statement of co-accused PLD 2005 SC AJK 65 confusional statements without getting signature of accused if otherwise recorded in confusional statement recorded in accordance with law is valid PLD 2001 CRC PES 1296 Number 4 judicial confusion. If judicial confusion is truly and voluntary made and on face of it, same can be relied upon conviction for offense so made out can be recorded 2000 MLD 875 confusion made by a person produced by the police from their unlawful custody is always considered to be invalid voluntarily made 2003 by law 2674. Number 5, confusion on oath. Confusion on oath is inadmissible in evidence 2002 PCRLJ 1072, 1999 PCRLJ 381. Number 6, confusion of accused in custody of police. Accused in custody of police for 3 or 4 days, confusion not voluntary 2002 PCRLJ 1072 PLJ 2002 CRC PESH 1403 PLD 2005 SC 159. Number 7, retracted confusion. Actual words used by maker have to be reproduced. Those are 8 MLD to 807. Retracted confusion not to be based for convection PLD PLJ 1999 SC 264, 1999 PCRLJ 1381 when can be taken into consideration 1993 SCMR 1574. Judicial confusion. Retracted punishment of had cannot be imposed 1990 PCRLJ 1878. Conviction cannot entirely be based PLJ 1999 SC 264. Trial court convicting accused relying on retracted confusional statements which was not recorded in accordance with mandatory provision of law. Non-compliance not merely irregularity but an illegality. Those are PCRLJ 465 retracting of 1977 SCMR 457 NLR 1994 CR 485. Retraction creates reasonable debate PLD 1994 FSC 24 if truth establishment retracted material PLD 1960 SC 313 PLD 1995 KAR 112 unsafe to rely upon a confusion much less on a retracted confusion 2001 PCRLJ 773 890 if voluntariness and truth of confusion is establishment. Retraction even if made shall not affected such judicial confusion and retraction would be wholly immaterial. Those are 3 PCRLJ 1264. Retracted confusional statement to be relied into to are excluded in its entirety not to be relied partly 2003 via 2801. Retracted confusion. Retracted confusional statements of a person if found voluntary and confidence inspiring must not be discarded for mere reason that it was retracted at the trial 2006 SCMR 1343 2006 PCRLJ 235 FSC. Retracted confusion of an accused cannot be used against the co-accused unless the other independent evidence establishing his connection with the omission of the crime is which case reliance can be placed on such retract confusion 2006 PCRLJ 62 extrajudicial confusion number 8 extrajudicial confusion a very weak type of evidence an accused cannot be believed to open his mouth with regard to the performance of his criminal acts unless there is a reason behind it 2004 MLD 910 extrajudicial confusion must be received with at utmost question status of the person before whom the extrajudicial confusion is made must be kept in view along with all material points and surrounding circumstances before acting upon a retracted extrajudicial confusion 2006 SCMR 231 नंबर 9 हदूद केस मजिस्ट्रेट not competent to record confusion 2001 PCRLJ 578 reasons to believe number 10 reasons to believe provision coached in negative language is mandatory in nature 1999 PCRLJ 1381 the expression is on a higher pedestal then mere subjective satisfaction of magistrate NLR 1999 CR LAH 453 number 11 non-compliance of the provisions of section 164 and 364 is not a mere irregularity curable but an illegality incurable 2000 PCRLJ 465 number 12 does not violate constitution provisions of section 164 and 364 CRPC are not violative of Article 13B of the Constitution. Rather, they are in consonance with Article 13 of the Constitution 2002 SCMR 364. Number 13 delay in recording confusion. Mere delay in recording confusion in principle is not fatal to the prosecution when the court is satisfied that the confusion is true and voluntary PLD 1994 FSC 24 and 1992 PCRLJ 756 1985 PCRLJ 2375 2004 MLD 180 confusion discarded when recorded 7-8 days after arrest PLD 2002 CRC PESH 1403 2002 PCRLJ 2021 delay in fatal PLJ 2003 CRC क्वेटा 257 नंबर 14 है evidentiary value mere denial of petitioner to have not made a confusion or the procedural defect in recording the confusional statements would neither affect the admissibility of confusional statements nor reduce its evidentiary value PLJ 2006 SC 41 सेक्शन 165 इंशाल्लाह कल पढ़ेंगे। तब तक के लिए मुझे इजाज़त दें। इजाज़त लेने से पहले मैं आप तमाम दोस्तों से रिक्वेस्ट करूँगा कि जो मेरे नए नए आने वाले दोस्त हैं मेरे चैनल पे, तो मेरी उनसे गुजारिश है कि मेरे चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि हर नई आने वाली वीडियो आप तक पहुंच सके और आप इससे फ़ायदा हासिल कर सकें।